none of us were there at the creation, but in 1878, the American Bar Association was founded. We didn't have a criminal justice section until 1920. Before that, in 1909, the Institute of Criminal Law and Criminology was created, and it worked hand in hand with the American Bar Association to deal with criminal justice issues. From 1910 to 1919, the Institute would have all of its meetings in conjunction with the American Bar Association meetings. We would announce their meetings. We would publish in our annual report the proceedings of the Institute. And then in 1920, the Criminal Justice Section was formed with an announcement that there would be a meeting in the 8th Circuit Court of Appeals in St. Louis. And at that meeting, there would be a Criminal Justice Section. They met in the morning, and then they met again in the evening, and we had a Criminal Justice Section. And then the next year, in 1921, the section organized 4 speeches at the ABA annual meeting, and they were a big hit. And that led to the formation of a special committee to look at criminal justice in America. That special committee reported, and somewhat surprisingly, given what we criticize now, in 1921, they basically said there were a lot of things wrong with criminal justice in America, and we had an inferior criminal justice section to that which existed in England and France. And the recommendation of the committee before it asked to be dissolved was that the ABA promulgate a model code of criminal procedure. They noted that the American Law Institute had already started that. And then in 1930, the ABA, the ALI, and the Association of American Law Schools all cooperated on trying to improve criminal justice in America. And then the criminal justice section was off and running. Surprising to some, there was a moment in the 50s and early 60s when the criminal justice section was largely law enforcement oriented. We had FBI people part of the section. And later on, things changed, and the criminal justice section became more controversial. Defense lawyers and prosecutors seemed not to cooperate anymore. And prosecutors took the position that the criminal justice section had become defense-oriented. And at council meetings of the section, prosecutors would sit separately from defense lawyers. They wouldn't talk very much to each other. And the criminal justice section had gone from cooperative to basically argumentative.
The section was founded in 1920. At that time, the American Bar Association, as well as the sections, were pretty much all white and all male. In fact, in 1920, when the section was founded, African American lawyers were really not permitted to be members of the section. There had been one lawyer who became a member, not of the section, but of the ABA. There had been one lawyer who became a member in 1912, and when his race was discovered, he was expelled. So the next African American lawyer was not admitted until 1943. The American Bar Association, unfortunately, in those early years, did not embrace diversity. And for that reason, in 1925, the National Bar Association, an association of African American lawyers, was formed to represent their interests. Since that time, the American Bar Association and the section of criminal justice in particular have really embraced diversity. In fact, the section has had 3 African American chairs, 2 men, one in 1993 and another in 2004, I believe, and then I became the first African American woman to chair the section in 2015. We have a council that is made up of rich diversity, not only diversity of race and gender, but also sexual orientation and religious diversity. Many of our committees, we've made a conscious effort to reach out to young lawyers and lawyers of color, because we believe that there's value to having all of those perspectives around the room when we're trying to make decisions to improve the criminal justice system. So I am proud of our section and our journey. We certainly will continue in that effort. In fact, there will be back-to-back African American chairs of the section beginning in August of 2020. So we're moving forward. 2000 2020 is the anniversary of the passage or ratification of the 19th Amendment, giving women the right to vote. It is incredible that, and coincidental, that the section of criminal justice has at the helm this year a woman, Kim Parker. We've had other women, and we will have a woman to follow her. Looking back on the journey of women, not only in the section, not only in the judiciary or in politics, but in society in general, we can see that the power that women obtain from getting the right to vote has led to women being in positions of influence throughout. We've influenced policy, we've had influence in the section, and I'm proud that the criminal justice section has really strongly supported women. We have recruited women, we have reached out, we have given women leadership positions because they have earned that. And I've been one of the beneficiaries of that. I think that as we move forward, even though currently women are not the majority in the association, they are the majority in entering law school classes. Their numbers are increasing in partnerships and law firms. I think that the future is bright for women, but women in leadership really benefits not only the entire association, our section, but they really benefit society. And I think if people are honest, when we look back, we might ask the question, what took so long?
I think the early priorities turn out to be the very same priorities we have today. It was improving criminal justice in all respects. And early on, we were able to attract judges, prosecutors, defense lawyers, some academics, to work on improving criminal justice in America. That was the goal. It always been the goal. I don't think that we defined it as well as we have today as the section being the voice of criminal justice in America, but that was the goal. Well, early on, one of the concerns was the lack of representation for indigents. We didn't really have that kind of public defense system that we take for granted today, although today it's still inadequate and poorly funded, but it was a lot worse early on. They did look at juries and basically how to get people to be willing to serve on juries, compensate jurors for their time in service. And it wasn't long before the section was rolling that the Standards Project started.
The Criminal Justice Standards Project was commissioned by the American Bar Association in 1964 in order to formulate comprehensive standards for the administration of criminal justice. The project was initially led by Warren Berger, then a judge of the Court of Appeals of the District of Columbia, which he continued to lead until his appointment as Chief Justice. Berger described the special committee that was to draft the standards as composed of more than 100 of the nation's leading jurists, lawyers, and legal scholars, operating in advisory committees of 10 to 12 each, with the participants drawn from every part of the country and including state and federal judges, prosecuting attorneys, defense lawyers, public defenders, law professors, penology experts, and police officials. He described the Standards Project as perhaps the most ambitious single undertaking in the history of the ABA. More than 50 years have passed since the first edition of the standards. 17 volumes in all were approved by the ABA's House of Delegates. Those original standards span the entire criminal justice process, including pretrial release, discovery, jury trials, sentencing, appeals, and post-conviction remedies. More broadly, they also covered topics like the prosecution and defense functions, the function of the trial judge, and fair trials and free press. A second edition of the standards was drafted by another equally distinguished special committee, and in 1986, the ABA House of Delegates created a standing committee of the criminal justice section to be composed of a balance of defense, judiciary, and prosecution. That standing committee, reviewing the work of particular task forces, each appointed for the purpose of revising a single set of standards, has produced third, and in some cases fourth editions of the original standards for approval by the ABA House of Delegates. Entirely new sets of standards have also been added, bringing the total to 25 volumes. These additional standards addressed a variety of specialized topics, including prosecutorial investigations, law enforcement access to third-party records, DNA evidence, technologically enhanced physical surveillance, court-appointed monitors, and the treatment of prisoners. When the first group of standards began to receive final approval from the House of Delegates, the criminal law section was given responsibility for coordinating the nationwide implementation of the standards to result from the project. The criminal justice section allocated money for states to apply for federal grants to enable them to compare their present laws and codes with the standards. The standards were an immediate success. As early as 1974, Chief Justice Berger reported that the justices of the Supreme Court and hundreds of other judges consult the standards and make use of them whenever they are relevant. They have been cited in more than 125 Supreme Court opinions, at least 5 of them in the last decade, and in some 750 opinions of the federal courts of appeal and 3,000 opinions of state Supreme Courts. Over the years, the Supreme Court has relied on particular standards in fashioning and applying constitutional rules concerning such matters as ineffective assistance of counsel, a prosecutor's Brady obligations, and a defendant's right to appear at trial free of visible restraints. Many jurisdictions have adopted the prosecution function standards in their court rules. A Superior Court judge in the District of Columbia described the standards as invaluable for trial judges and recommended that a set of the standards should be readily available and preferably on or near the bench at all times. The standards have also been relied upon by legislators, prosecutors, defense attorneys, and scholars who recognize that they are the product of a thoughtful consensus reached by balanced committees made up of prosecutors, defense attorneys, judges, and academics. Dozens of states have used the standards in revising their criminal codes. Prosecutors and defense attorneys have found the standards useful, not only in supporting legal arguments they make in court, but also in guiding their own conduct and in training and mentoring colleagues. The standards have also made their way into law school casebooks and thousands of law journal articles. Entire symposia have been devoted to the consideration of particular standards and the issues they raise, and to the development, implementation, and significance of the standards. Planning for the future of the standards is now underway. In addition to being published in book form, the black letter standards are now posted online at the ABA website, and for some standards, the commentary appears there as well. A special task force has been created to examine the standards as a whole, present them online in a logical, chronological format, harmonizing overlapping standards, and making explicit when a newer standard has superseded or amended an earlier one in a different set of standards. All those who have participated in the Criminal Justice Standards Project, past and present, can take immense satisfaction in the standards' quality, in the high regard in which they have been held, and in the frequent use that they've enjoyed since the inception of the project more than 55 years ago.
I joined the section in May 1980, almost 40 years ago. Amazing. I remember some of the work that the section did, that they focused on. I know juvenile justice, there was a juvenile justice implementation project, and that came before the juvenile justice standards. The criminal justice standards was already in play, and some of those, we worked on updating them. There was a lot of work on the grand jury project, I remember that, and the Criminal Justice magazine.
In the late 80s and early 90s, the criminal justice section decided that it had to put to rest this lack of cooperation between prosecutors and defense lawyers. And basically, it was a huge effort to assure both sides that we were going to be a balanced section. And we adopted policies that we continue today, which we rotate the leadership of the section. We're very firm about this. We have a prosecutor who chairs the section, followed by either a defense lawyer or an academic/judge. And those three rotate. and the rotation assures that everybody's represented. I don't think we were always in the past as successful as we now are in trying to assure that the council is about evenly divided between prosecutors and defense lawyers. We work very hard now. I think at times in the past, we didn't always achieve balance. It wasn't because we were trying to be imbalanced. Some of it was because prosecutors weren't applying for counsel. That grew out of our history of prosecutors not feeling as welcome as they should have been. In 2003, Justice Anthony Kennedy challenged the American Bar Association as a whole to try to step up to the plate and to improve criminal justice. He made it clear that the association couldn't depend on the Supreme Court or federal courts to fix the problems in criminal justice. The president-elect of the ABA, Dennis Archer, our first African-American president, asked me to chair what was called the American Bar Association Justice Kennedy Commission. We reported, a year to the day that Justice Kennedy spoke, 6 recommendations to the House of Delegates. The Department of Justice sent the Associate Attorney General to oppose the first and most important of our recommendations. But it passed the House with a large vote in favor. All 6 of our resolutions passed. The Kennedy Commission was followed by the Commission on Effective Criminal Sanctions, which made additional recommendations for reform. And I'm really proud to say that each of those recommendations has been adopted somewhere in the United States today. It's been a revolution. And a lot of those reforms have been supported by prosecutors, defense lawyers, judges, and academics across the board. It's the creation of the collateral consequence database, which we undertook with a grant from the Department of Justice. But by the time we were done, we spent twice as much of our own money as the department gave us. And we created this national database of all of the collateral consequences of conviction. And when people saw that there were approaching 50,000 collateral consequences, it caused heads to turn. And people began to take another look to see what are we doing to people who've paid their dues and can't get on with their lives because they're disqualified from so many things in America. When President Obama announced his clemency initiative, we cooperated along with 4 other organizations to put together a team that filed clemency applications on behalf of thousands of federal prisoners. And we assisted in having 1,600 or 1,700 of those prisoners granted clemency. It was a huge effort, and once again, we spent a lot of criminal justice money in support of it, but we were proud to do it.
I remembered when the council or the section decided to broaden its reach. And I think that was pretty important. So they brought other people, other areas of the criminal justice system into the section. I would say opening up to the public defenders especially, who found the ABA to be a big wall. They couldn't afford it, number one, because you had to be a member of the ABA, and even though section membership was, reasonable, they couldn't afford the hundreds of dollars to, pay in. But we did have a chair at that time, Terry McCarthy, who was big on bringing these groups in. And he found a way, he worked around the ABA. He found a program, an affordable dues program that he pushed mightily to get these, people in. And after that, stemming from that, we had, our first female chair, who was a judge here in DC, and our first African American chair, who's a professor in Chicago now. And, it did go from there. The section grew and developed. When I joined the section, it was smaller. We didn't have much money, So the section depended a lot on grants. Um, so we kind of had to choose where the focus was going to be. We didn't have a lot of money to do what, fulfill the dreams. And after the section developed more programming and started earning some money, they could have, go in all different directions. So I think the programming enhanced the section.
Talking about the role of women in the section, there are a few specific examples that I would mention that I think are very powerful. One, the section, as I mentioned before, has a rich history of leadership by women in the section. But in particular, there are projects of the section that really emphasize women. For example, there's recently been appointed in the last 2 years a task force on women in criminal justice. The task force is aimed at looking at the barriers that women face to fully participating in the section. There have been listening sections conducted all around the country by specific groups and then broadly to determine what are the things that women are facing as they try to fully participate in the profession. What are some of the things that are keeping women out of criminal law practice as prosecutors or as defense attorneys? What are some of the issues that judges face? So that's a project that I think is really incredible, and it is going to generate a powerful report that hopefully will help us as a profession address those issues and remove those barriers. Another example of the section's commitment is a resolution that addressed incarcerated women. We found that in jails and prison, women were often denied basic hygienic needs. The section passed a resolution to shine light on that problem and also to rectify those issues. It's a basic human right that women should not have to go through degrading denials of basic hygienic needs. And this resolution really condemns that and asks for policy to prevent that from reoccurring. The resolution is important because resolutions are used to get policy, and we actually go and advocate for the resolution to change that pernicious problem. The section has embarked on a number of projects to increase or address diversity and inclusion. One has been our Fellows program that reaches out and identifies lawyers of color to bring them in, introduce them to the section, and get them involved in the work of the committee. They bring great ideas to the section, and we run with some of them, and some of them obviously are folded into other existing programs. We have a diversity and inclusion committee that is geared to addressing the continuation of the rich diversity that forms our section. We have had projects that dealt with clemency. Many of the disproportionalities in sentencing were addressed through that project by looking at African Americans who were traditionally sentenced to longer periods of time and addressing those issues and helping them to seek early release. One of the programs that I'm most proud of is our project on implicit bias, where we are actually going about the country training individuals about the pernicious effects of implicit bias and providing dialogue and training to interrupt or address those implicit biases, because it can have a very negative effect. And it's not just race and gender. It's also poverty or socioeconomic conditions that can really be affected by that. We have produced a book called Enhancing Justice and Reducing Bias, which is a resource guide for lawyers and judges geared to making people aware and giving them tools to eliminate bias. The American Bar Association has not always stood up boldly in instances of societal conflict, but I do know that we have a rich history of addressing those problems. For example, the section put out a pamphlet on addressing social disorders and addressing information or problems that were brought about through inequalities of society. In fact, during the turbulent time of the civil rights movement, the section strongly recommended, the appointment of counsel for poor people and addressed a number of other issues to try and bring about equality in the criminal justice system. And I think that we have cause to be proud. We recognize that there's always room for improvement, but there are also sources of pride that should be celebrated when it's appropriate. Earlier, I mentioned a source of pride, the Implicit Bias project, which is a project of the criminal justice section. We have gone through phase 1 and generated a book, a resource guide for judges and lawyers. And part of that guide really makes people aware of the issue of implicit bias and the pernicious effects that it has potentially on our justice system. The awareness is the first step. And we talked about broadly some bias interrupters. There's a second phase of that project that we're now embarking on, and that is a practical guide, a practical approach, the development of tools that people can use, checklists, examples, lessons that people can use and translate into bias interrupters. And I believe that that is going to be a really significant contribution to the work. It is one thing to become aware, and I had a relative who used to tell me that once you know better, you're obligated to do better. And we believe that knowing better and training people on how to do better will help us to achieve more just and equitable outcomes and reduce disproportionalities in the justice system. That is a source of pride. That is work that the section is committed to, and it makes me very proud of our section.
Our section is made up of a lot of different committees. For example, we have the Prosecution Function Committee, the Defense Function Committee. What we ask is for them to try to develop different standards and policies that would be the best practices within the criminal justice world. Once they've developed that, it has to be approved by the Criminal Justice Section Council. Our council is made up of the defense bar, academics, as well as the judiciary and government employees. They're able to look at that and scrutinize it to make sure that we develop the best policy so that everyone is at the table and trying to make an agreement on what we think the best practices are. The criminal justice section really looks favorably on young lawyers. On our section council, we have 2 positions that are marked specifically for young lawyers. In addition to that, we have our fellowship program. This is a fantastic opportunity for young lawyers across the country to try to apply for a scholarship sense so that they can be a fellow within the section. One of the benefits of being a fellow is that you get an opportunity to attend our meetings for free. You get to network, you get to collaborate with other young lawyers as well as some of our senior members to try to develop policy and best practices for criminal justice. We understand that the law students are our future generation for the practice of law, specifically on where criminal justice is going to evolve. We've been very aggressive that whenever we've had meetings in different states and cities, that we try to reach out to the local law schools where we've done career panels on various jobs within the criminal justice world. This gives law students a great opportunity to meet with decision makers, to meet with the judiciary, to meet with other individuals that they might not be able to come across in their normal everyday lives in law school. This has been a big win, not just for them, but also for us, because it also helps us feed our pipeline of leadership for the future. Our future is very bright, and a lot of it is indicative of what we've done in the past. We've been the leader in terms of criminal justice reform. We've been very aggressive in going into some of the different communities across the country, dealing specifically with some of the different various state legislatures to try to help them in guidance of various aspects of criminal justice reform. That's something that we're all very proud of. And I think that moving forward, we're just going to continue to do that. In addition to that, we've had an eye on what our future leadership is going to look like. And we've been very aggressive of trying to bring in young lawyers as well as law students to try to groom them to be our session council's future leaders. One of the best aspects of being an active member of the criminal justice section is the opportunity to meet so many people from across the country. Our best asset in terms of the criminal justice section is our membership. We have some of the best people, period, within the APA. And they are very passionate about the work that they do. I've benefited as a former prosecutor by just being around at the table and able to listen to different elected officials from across the country, as well as the defense bar, which has opened my mind and it's helped me take things back to my local jurisdiction. And I think it's made me a better prosecutor.
Oh, I think the greatest strength of the section, its members. It's, a vast resource of members that covers, A to Z in criminal justice system. And it's a wide talent. I'm always impressed. So whatever issues should arise, there's someone who can address it, whether it is writing, something for the magazine, or writing for a grant, or going up on the hill to speak. There's just someone who, all the experts that we have.